Yes.
Lord, can I start by dealing with the matter that my Lord Clerk raised this morning concerning reflective loss? In my submission, the correct position is this. First of all, the claim for personal loss was a claim for reflective loss. Secondly, the general rule is that a recovery of for reflective loss will not be permitted. Johnson and Gorwood. Johnson and Gorwood was a case where the company, of course, had already recovered as regards reflective loss by its settlement with the wrongdoer. And there is an exception to that rule of non-recoverability, at least one that's been considered, and that is where the mechanism for enforcing the legal right is itself defective by reason of the wrongdoing, or indeed the wrongdoer. And that authority for that is to be found in the case of Giles and Rind number 1. That, I'm afraid, is not the case we have in the bundle, which is Giles and Rind number 2. But it is a case that was considered in a case we do have in the bundle of authorities at Authority 63, and that's the recent case of Webster against Sanderson Solicitors.
Which was the one that was disapproved in Hong Kong?
Giles and Rind.
Number 1 or number 2?
Number 1.
Right.
And in Webster and Sanderson's, the rule in Giles and Rind was set out and summarised at paragraph 37, which is, it's incorporated in a qualification to the Johnson and Gorwood principles. And the first principle is that a loss claimed by a shareholder which is merely reflective of a loss suffered by a company, that is a loss which would be made in good if the company had enforced in full its rights against the defendant wrongdoer, is not recoverable by the shareholder, save in a case where, by reason of the wrong done to it, the company is unable to pursue its claim against the wrongdoer. And that's, as I say, the authority is at number 63 in volume 5, and that is at paragraph 37 of the judgment of my Lord Clerk.
So what do you say then about Giles Rind if it's doubted by Lord Millett?
Well, I really wouldn't want to get into resolving that if it was not necessary for the argument. The point that I'm making in response to my Lord Collins is that we're in a position where the estate is itself insolvent, and we say certainly one of the reasons it's insolvent is because of the wrongdoing of the defendants. And in those circumstances, it is at least arguable that the exception to Johnson and Gorwood set out in Giles and Rind applies, and therefore there would be a good personal claim as well as a good claim by the administrator.
Perhaps your answer to Lord Collins is in paragraph 36 of Lord Clerk's judgment, because he picks up the point that Lord Millett thought that Giles and Rind was wrongly decided, but he says, I'm really putting words in my Lord's mouth, but it's binding on this court and recent decision and right to follow it. And so far as this jurisdiction is concerned, you would say the same, would you?
Well, my Lord, of course your Lordships aren't bound by that decision, but for present purposes I'm not seeking to persuade your Lordships any differently. I hope that deals with my Lord Collins' point. The second specific point arises from the rules of the Supreme Court in relation to company derivative actions. My junior and I have considered the rules as they existed before the CPR in RSC Order 15, Rule 12A, and there was, as far as we can see, no requirement of joinder of the company in a company derivative action under the rules. It appears from the notes to the White Book that the former version of CPR 19, Rule 9, Sub-Rule 2, which does require joinder, was created in 2000, came into force in 2000. So that would have been extant at the time of the application to amend in this case. The third point that arose was the mandatory wording of CPR 19 Rule 9, and it was put to me what the difference was or would have to be between wording such as must and should, and of course there is a difference between them. The distinction I would seek to draw is not a distinction between must and should, but as I've indicated, a difference between procedure and a necessary party to a legal cause of action. And one way of illustrating that difference is that if there is a failure to join a necessary party, then the consequence of that is that the defendant is entitled to strike out the claim. It simply discloses no cause of action. If, on the other hand, there is a failure to comply with a procedural rule, then the consequence is that the court will exercise, in effect, its powers of sanction in respect of the claim, may give an opportunity to mend a person's ways, and may punish appropriately. That is a matter for the court. As a matter of fact, where the rules require must, and must can be dealt with simply by putting a name at the top of a form, and a person willfully refuses to do that, it's likely that the sanction which we'll end up with is the claim will eventually be struck out or dismissed. So one would end up in the same place, but one would do so by a different mechanism and a different procedure, illustrating that they are different sorts of obligation. My Lord, lastly this, as the matter's out of step, I referred to the authority of the Court of Appeal in New South Wales in respect of whether a derivative action has to be permitted or not. In fact, that's been considered, it seems, in one other jurisdiction, and that is in Scotland. In the case of Wilson against Inverness Retail, a decision of the Outer House, authority number 65 in the bundle.
Volume 5.
5.
Is it? No,
Yes.
it doesn't look right.
66.
Sorry, that's
66. 5.
66.
The substantive question in this case was whether, in fact, a derivative action could exist in Scotland or not. Following an earlier decision, which is in the bundle, Lord EC said that held that it could. The next question that one question that he was asked to consider was whether permission had to be sought before the action could be brought, and counsel for the defenders said that it did, and their argument relied on a summary of English procedure set out in the Court of Appeal decision of Barrett and Duckett, and that's to be found at paragraph 11 of Lord East's judgment. And in particular, the 6 principles there sent out, and they relied on principles 4, 5, and 6. I think in particular 4, where a challenge is made to the right claimed by a shareholder to bring a derivative action on behalf of the company. It's the duty of the court to decide as a preliminary issue the question whether or not the plaintiff should be allowed to sue in that capacity, and submitted that paragraphs 4 and 5 in particular indicated at letter E that a minority shareholder wishing to bring a derivative action required to obtain the prior permission of the court. Pausing there, in my submission, it's absolutely plain that the passages from Barrett and Ducker don't say that, because at paragraph 4 it indicates that that is a procedure to be gone through when a challenge is made to the right claimed by a shareholder to bring a derivative action. So it's, in effect, a decision which has to be made only when that is put in issue. But be that as it may, that was the assertion. And Lord Easy dealt with that at paragraph 25. And in effect, as I understand his lordship, he held that whatever the position in England, that wouldn't be the position in Scotland. For the reasons advanced by counsel for the pursuers, I consider the invocation of those points, that is points 4, 5 and 6 in Ducker and Barrett, for holding this action incompetent is misconceived. Points 4 and 5 may be taken together. They both concern essentially English procedure rather than a substantive test of competency or relevancy. In Scottish procedure and terminology, a preliminary issue of competency or title to sue may of course be addressed, but it's addressed normally by the tabling of an appropriate preliminary plea of incompetence or no title to sue, which may then be dealt with either by debate or, if need be, by a proof before answer on a question of competency on title to sue in the event that the averments pertinent to such an issue are disputed in fact. I can see no reason wherefore the normal test and procedure should not apply in an action such as the present. Nothing in the Scottish authorities suggests otherwise. I think notable that in advancing the Barrett and Duckett summaries applicable in Scottish procedure, counsel for the defenders who had requested the debate on their preliminary plea then submitted the matter of the pursuer's entitlement to sue could not be decided by the debate on the pleadings which they had sought in the first place. As I understand, in effect, that was an issue on the pleadings and not with evidence. It's not suggested by counsel for the defenders that there be a proof on any particular disputed averment relating to title to sue. It appeared to me that in the context of Scottish procedure, counsel for the defenders were effectively at a loss to give any content to their reliance on points 4 and 5 of the Barrett v Duckett synopsis, other than to suggest that in the present case the preliminary issue fell to be addressed in the 459 proceedings in the Sheriff Court. In short, despite profession by counsel for the defenders to the contrary, the submission for the defenders effectively has to resolve into the proposition that a derivative action may only be brought if the intended pursuer has already obtained in a section 459 proceeding permission to bring such action by virtue of an order under 4612C. But that's plainly not the import of points 4 and 5 of the Barrett and Duckett summary. The defenders' reliance on that part of the summary, which is essentially concerned with English procedure, is accordingly misplaced. So, my lords, in my submission, one, the submission was wrongly made. It doesn't reflect English law. And secondly, his lordship could see no reason why in Scots law and procedure such a matter and procedure was a necessity. Lord, I can then turn on, I hope, to deal quickly with the outstanding matter of argument by analogy relating to joinder, which impressed itself to the Court of Appeal. We've looked at the rules which govern both this case and company cases. The one thing we haven't looked at in any detail is the question of the joinder of the legal owner if you have a claim in equity to enforce, for example, a contract by an equitable assignee is the typical case, or the assignee of a debt. The Court of Appeal relied on the Performing Rights Society case as showing that it was necessary to join a legal owner of the cause of action. In my submission, that is simply a matter of procedure. As I've indicated, in fact, Her Ladyship, Lady Justice Arden, appeared to have considered the same, and the current position of the law is as set out in the case of Three Rivers District Council against the Bank of England at 313. My Lords, I've set out really the line of authorities that are referred to in that case. I rather hope that your Lordships don't wish to be taken through Grant and Dunlop and Performing Rights Society to ascertain whether a legal owner must be joined in order for a legal remedy to be provided in an action brought by a party equitably interested. Because although that is an issue which has taxed academics for many years, indeed continues to do so, the position in the courts, certainly as far as the Court of Appeal is concerned, appears to be settled. So if I can take your lordships to authority number 58 in bundle 4.
Do we go straight to page 313, or do you want us to look at some of the earlier passages?
My Lord, I'm simply going to ask your lordships to note as it were, the scope of the consideration in the judgment.
Yeah.
The analysis really starts at page 307, letter F, where Lord Justice Peter Gibson says, I start at the first question, that was whether the writ should be amended in the way that BCCI sought, to allow, in effect, the parties beneficially interested to be named in the claim, but without them seeking any remedy. That was the strange aspect of the claim. And his lordship then analysed what appears to be all of the relevant authorities on the topic, including Grant and Dunlop at 308 C to D, Performing Rights Society and London Theatre of Varieties at 308 G, Walter and Sullivan and Murphy, a case we haven't cited but it's pertinent to that issue, at 310A. Particularly important in the analysis is the ILOS, Court of Appeal, judgment of Lord Justice Oliver, as he then was, at 311D. Weddell against Pearson Major, 312E. And Deposit Protection and Dahlia at 313C. And the conclusion that's reached is at 313F. These authorities, in my judgment, clearly establish that the equitable assignee can be regarded realistically as the person entitled to the assigned shows and is able to sue the debtor on that shows, but that, save in special circumstances, the court will require him to join the assignor as a procedural requirement so that the assignor might be bound and the debtor protected. If unusually the assignor sues, he will not be allowed to maintain the action in the absence of the assignee. That it is the assignee who normally sues, asserting the claim as his own, with the assignee nor as a non-claiming party, can be seen from Bullen and Leake and Jacobs' precedents on pleadings and Atkins court forms. So I say that is the position as far as equitable assignees bringing an action is concerned. They'll usually be required to join the legal owner. Not always. Special circumstances, they won't. But that is a matter of procedure if they are required to join the legal owner, essentially in order to protect the legal debtor from further claims. My Lord, that I submit is a helpful and accurate summary of the law. Having said that, I pass on to the question of limitation. My Lord, the relevance of cause of action, as we've looked at it, is this, that section 35 is only triggered.
So what does that mean? That if you're an equitable assignee, you can start the proceedings without joining someone else, and what happens then?
Well, that usually you will be required, if there's an issue about it, to join.
Well, first of all, if there's no issue about it,
you can just go on.
You can go on. Is that right?
As I understand it, there's no suggestion that the court will, with its own motion, stop you from doing that. The reason why a legal owner is normally joined is because protection should be given to the debtor, so that he's not going to be sued by somebody else claiming a better title than the person who's actually brought the claim. 30 years ago, the practice would probably have been to say nothing in court if the point wasn't raised by the legal owner. Nowadays, I think there might be a slightly different practice in that the judge might want to know whether, in fact, the defendant actually wanted to take those steps or not. And if he didn't, he'd get it expressly noted. But it would be a matter for discussion between the parties and then for a matter.
But the critical question in the present case is whether or not you have to join the assignor at the outset, so that if you don't, and then the limitation period expires, you're stuck. Is that right? That's what the case is about. I mean, in the ordinary case, it doesn't really matter whether you join in real life. In very many cases, it doesn't matter whether you join the assignor or not, because the assignor will very often be quite willing not to be joined, doesn't mind whether he's joined or not.
But your client is not an assignee, nor is he in a position analogous to an assignee. So I don't really know why we're spending quite so long on this point.
We're spending probably an excessive amount of time on the point because the Court of Appeal relied upon this analysis in coming to its conclusion that the administrator had to be joined. They said that all of these cases are analogous, whether it's derivative actions, whether it's equitable assignees suing must, whatever that means, join the legal owner. And my submission is that insofar as the Court of Appeal may have thought that must meant you must, otherwise you don't have a good cause of action, and they relied on the equitable assignees cases to prove that, they fell into error.
Well, they would perhaps have said that your client's position was a fortiori, but that's...
My lord, yes, they might well have said that, but that would be a matter of degree and not as a matter of principle in my submission. So if we start from the point that it's accepted that it's purely a procedural matter and not a matter of legal obligation, as I've defined it, then one can leave it there.
Okay, let's see how that works then. Assuming that you're right about that, you say if the point is not picked up at all, the court won't insist on it of its own motion, and the case will then proceed without the point ever being discussed. And limitation, I mean, assuming the claim was brought in time, the limitation issue simply wouldn't rise above the surface.
Well, that's right.
Are you saying that if the point is taken by the defendant after the limitation period would bite, it doesn't raise a limitation issue because it's purely procedural?
Well,
is it as simple as that?
It is, I'm afraid, as
Does one
simple
get
as that.
anything from Section 35 to bolster that, or?
Simply this. Section 35 relates to the generation of or the creation of new claims, the bringing of new claims.
Whereas we should test this at the stage of assuming there's only one claim.
Yes, if there well.
I mean, if you issue your writ against X, and then you later, just taking my lord's point, or subject to my lord's point about being irrelevant, just taking the equitable assignment as an example, if you do start proceedings in the name of the assignee, then the argument is that if you don't also issue proceedings in the name of the assignor, the relevant action has not been commenced within the meaning of the statute. Is that right?
That's what we said, yes.
Join them as a defendant, then what?
You either
Because
have
this is
to,
all about commencing proceedings, isn't it? I mean, if the assignee commences proceedings, and you name the assignor as a defendant, then what?
well, this is where we come back to the meaning of Section 35. Shortly, Section 35, which followed on from the 1977 Law Reform Committee's report, was enacted in order to remedy problems which had arisen with limitation. It was enacted in order to make it easier to bring claims and to remove from the ambit of the Limitation Act claims which would have previously fallen foul of it but shouldn't have done. The Law Reform Committee proceeded on the basis that whenever there was a necessary additional party who had been left out of account, that the bringing of that additional party into account triggered the Limitation Act. In other words, he was a necessary legal party. And this was the case whether it be one of joint obligees being entitled to suing, or whether it was the case of a person bringing a derivative action. That was the assumption under the Law Reform Committee adopted. And my submission is that, in fact, that may have been the assumption, and that may have been what the Act was intended to do. But it doesn't apply in these cases. It doesn't apply in these cases because they are not legally necessary parties.
Who are not? Who are not the legally necessary parties? I mean, in the case of a joint obligation, are both parties not? Do you not have to have both parties there? I thought that was exactly the sort of situation in which that you did have to have them. I mean, in Scots law, it comes under the rule, the defence is all parties not called.
Yeah. Lord, it may be that answers, if that is so, that answers a question which your Lordship raised before lunch, which is, are there circumstances where you can bring a claim where there aren't necessary parties before the court? If that is so, then that would be right. That would be fine. But the position I'd suggest is different, where you have a derivative action of any sort, or whether you have a person bringing an equitable claim in respect of a legal right. In those circumstances, the legal owner is not, in the same sense, a necessary party. Well, I can't say whether in Scots law the same defence would operate in those circumstances. But that is the division which the Act brings. Well, having referred to it for so long without having actually gone to it, perhaps now it would be a convenient time to go to section 35 of the Limitation Act, which is in the core bundle at enclosure 5. Section 35, page 75 in that bundle. Section 35, subsection 1, states that a new claim should be deemed to have been commenced as a separate action and commenced B in the case of any other new claim on the same date as the original action. So it brings into force the relation back theory of amendments in respect of that is why there needs to be a restriction on amendments outside the limitation. And critical for these purposes is subsection 2. In this section, a new claim means, 1, I put in that, any claim by way of a settle for counterclaim, and 2, any claim involving either A, the addition or substitution of a new cause of action, or the addition or substitution of a new party. And the question in my submission that the statute throws up is, what is a claim involving the addition or substitution of a new party? Does it refer to an alteration of a new party for merely procedural reasons, or does it refer to the substitution of the addition of a new party where that is necessary to get your claim on foot, where it never was on foot without the addition of the new party? That Act goes on to provide, first of all, by subsection 3, that except as provided by section 33, well, that deals with personal injury actions, and that's not applicable here, or by rules of court, the High Court and the County Court will not allow a new claim within 1B above, other than an original settle for counterclaim, to be made in the course of any action after the expiry of any time limit under this Act, which affects a new action to enforce that claim. So that's the Limitation Act cut-off in respect of new claims. And then we have the gateway to allow amendments for rules of court may provide for allowing a new claim to which subsection 3 above applies to be made as they're mentioned but only if the conditions specified in subsection 5 below are satisfied and subject to any further restrictions the rules may impose. And then we have 5 and 6, which define the circumstance in which you can join a new party within that definition. 5A is if you have a new cause of action, it's if the new cause of action arises out of the same facts or substantially the same facts. And B, in the case of a claim involving a new party, if the additional substitution of the new party is necessary for the determination of the original action. And necessity is defined further in subsection 6, is not necessary unless either A, the new party is substituted by way of a mistake, that doesn't apply here, or B, any claim made in the original action cannot be maintained by or against an existing party unless the new party is joined or substituted as a plaintiff or defendant in that action. Now, 6B gives us a clue as to why there's been so much argument here about causes of actions and claims. If the position is that there is an existing claim which cannot be maintained unless a new party is joined, then that's all right. You go through that particular requirement. So if the claim that is being brought is a claim, and always has been, a claim by the claimant here, in respect of a cause of action, which has always existed, being the negligence of the solicitors in respect of this claim, then because you, if it be the case that you have to join the administrator in order to maintain that action, you can do that now. That's the effect of section 35(6)(b). The other argument on the Limitation Act, the point on the Limitation Act, is the more basic one, that if you have simply a procedural amendment, then the claim simply isn't a claim involving the addition of a new party, and therefore doesn't fall within section 35 subsection 2 at all, and therefore the grounds for amending are those contained within CPR 19.2, which is the general power of amendment, addition of parties, and not CPR 19.5. Coming back to the case, the Court of Appeal have considered the position of a party who simply needs to amend outside the limitation period by substituting a successor party in the case of Yorkshire Regional Health Authority against Fairclough Building Limited, and that's at Authorities Volume 5, Authority 68. It's the very last authority in that bundle. My Lords, this was what one might think as obvious a case of amendment as one could ever find. It was a case in which a claimant under a building contract had changed in effect its legal identity by virtue of statutory succession. And the successor applied for leave to substitute itself for the former health authority, and the point was taken against it, point totally without merit, that was prohibited by section 35 because the limitation period had expired. And Lord Justice Millett considered the legislation his consideration starts at page 216, letter G, as Lordship sets out section 35 of the Act. And he asks himself at 217G whether the substitution of the trust for the Yorkshire Regional Health Authority was a new claim in the meaning of section 35 of the Limitation Act 1980. And at page 218, the Lordship says this: the second defendant's argument is simplicity itself. The Trust's claim, as they submit, falls fairly and squarely within the second limb of section 35.2 as B, any claim involving the additional substitution of a new party. The Trust is a new party. It is, they submit, as simple as that. It is not, however, as simple as that. Closer analysis of subsection 2 shows that subsection 2 cannot be construed literally. This is because the remainder of section 35 assumes that the two limbs of the subsection are mutually exclusive. A new claim within the first limb is subject to the conditions imposed by subsection 5a. A new claim within the second limb is subject to the conditions imposed by subsection 5b. But if subsection 2 is literally construed, the two limbs are not mutually exclusive. A claim may involve the bringing of a new cause of action by the addition or substitution of a new party. This difficulty cannot be resolved by the simple process of applying words into subsection 2 so as to make the two limbs mutually exclusive, that is to say, reading it as if it read 2. In this section, the new claim means A, any claim involving a new cause of action but not involving the additional substitution of a new party. B, any claim involving the additional substitution of a new party but not involving a new cause of action. This would leave a claim which involved the bringing of a new cause of action by the addition or substitution of a new party unprovided for. In my view, the antithesis is between a claim which involves the additional substitution of a new party and one which does not. The first limb must therefore be confined to claims which involve a new cause of action but which do not involve the additional substitution of a new party. Claims which involve the additional substitution of a new party as well as a new cause of action fall within the second limb. The question is whether the second limb also includes claims which include the additional substitution of a new party, but which do not involve a new cause of action. In my opinion, it does not. As I have already pointed out, there are two entirely different kinds of substitution provided for by the rules, one where the party substituted has succeeded to a claim or liability already represented in the action, and one where he has not. It would be outside the scope of the Act of 1980 to alter the law relating to the former kind of substitution, which involves no question of limitation. So, my Lord, in his Lordship's opinion, the provisions relating to the involving new parties under section 35.2b did not involve the addition, or in that case, the substitution of a new party, where no new cause of action was being asserted. Of course, it follows that if no new cause of action is being asserted, it's the same cause of action as previously existed, and therefore there wouldn't be a matter for the Limitation Act to bite on.
So it's neither A nor B.
That's right, if it's simply the substitution of a new party. In my submission, if a court should simply say, well, we think you should join X, then that is not the creation of a new cause of action, it's simply the addition of a party, and following Yorkshire RHA, it's not a prohibited amendment. Lord,
it doesn't. There's no reason why the statute dealing with limitations should apply its mind to that kind of new party. Is that right?
Well, that's right. Of course, the Yorkshire Regional Health Authority case was such an obvious case that, in a sense, one's looking for a legal analysis which justifies that conclusion. I fully accept the case that's before your Lordships is rather more complicated in terms of its analysis and construction than that case ever was. But in my submission, the principle is clear that if there is no new cause of action as a necessary part of the joinder of a new party, then section 35.2 doesn't apply. I think the wording that Lord Justice Millett used was a claim involving the additional substitution of a new party which includes a new cause of action. That, in my submission, is an accurate analysis. Lord, as we've seen in section 35, section 35 is talking about new claims. A claim is what is sought, is relief that is sought by litigation. And the parties who are involved in a claim within section 35 subsection 2 are those whose presence is necessary for the claim to be validly made. In the case of a derivative claim, that is simply, in my submission, the party seeking to enforce the equitable right, in this case the beneficiary, and the defendant. Lord, I'm going to, if I may, refer your lordships at this stage to the 21st report of the Law Reform Committee, which is at...
Just before you do that, how then does your analysis apply to the facts of this case?
On that particular submission, we say, yes, we're joining a new party. No, we are not raising a new cause of action. Therefore, the amendment does not involve a new party within the true construction of section 35, subsection 2, paragraph B. Therefore, the prohibition on joining that new party in section 35 does not apply. Therefore, the court instead simply has to consider its ordinary jurisdiction to allow amendments under CPR 19.2, not CPR 19.5.
You've dropped your voice there. Consider under CPR.
CPR 19.2, not CPR 19.5. Well, there's one, if I can, alternative way of putting it, which perhaps I can deal with at the moment. This is at 3.12 in the case, 3.11, 3.12. It's something of an oddity. That CPR 19.5 is not in the same wording as section 35. CPR 19.5, I think, can be found in volume 6 of the authorities. Well, the suggestion here is that by the wording of the rules, in fact, 19.5 seems to be wider than section 35. It's perhaps worth turning back to 19.2 at page 454 in the White Book.
I'm not quite picking up where you're looking at, I'm afraid.
Oh, sorry.
Are we looking at...
It's volume 6, authorities volume
6, I'm so sorry.
So that's where we put the rules.
Yes. So we were looking at 19.5 and...
Well, if one starts at 19.2, it's 454.
Yes.
That's the rule that governs changing parties in general.
Mm-hmm. So is it what party is being added or substituted here then?
Lords, as Virginia reminds me, if there is an order for joinder of a person, that's the person who would be joined. 19.2 deals with the addition of any party in general, and it provides that this rule applies where a party is to be added or substituted, except where the case falls within Rule 19.5. And then it's subheading. And basically it says the court can order a new party to be added for good reason, and a party to be substituted if there's succession of interest and it's desirable to do so. So it's a fairly wide power. But CPR 19.5 governs that. If you fall within CPR 19.5, you cannot fall within 19.2. And 19.5 says this rule applies to a change of parties after the end of a period of limitation under A, the Limitation Act 1980, amongst others. And the court may add or substitute a party only if, and then you have relevant limitation period current when the proceedings were started. And 3, the addition or substitution of a party is necessary only if the court is satisfied that, and then you have 3 requirements. Substitution for a party named by mistake, can't be properly carried on by or against the original party, or the original party has died or had a bankruptcy order made against him, and his interest or liability has passed to the new party. There is no reference in CPR 19.5 to there being a new action or the original action having a certain characteristic. It's simply not referred to here. The question is whether the language that's been used here is different and wider, and the suggestion that it is can be seen most clearly under Rule 19.5 Subrule 3C, which provides an additional reason for successors to be bound, to be entitled to be joined, namely where the original party has died or had a bankruptcy order made against him and his interest or liability has passed to the new party. That isn't a provision which is found in Section 35, subsections 5 or 6. No. And it appears that it's been added into 19.5, well, for reasons that I'm afraid are not terribly clear at all. It seems to replace the old rule of the Supreme RSC Order 15 Rule 7, which governed changes in the identities of the parties, but which applied whether the limitation period had expired or not. Now, insofar as it may be said, well, CPR 19.5 applies even if Section 35 doesn't, our submission is that the wording in 19.53 B, the claim cannot be properly carried on by or against the original party unless the new party is added or substituted as claimed or defendant, is by necessity wider than that contained within Section 35, Section 5, and it's wider in order to cover procedural amendments. That if that is right, CPR 19.53b covers procedural amendments, and that is all.
I'm slightly lost in that last little canter. We just have that bit again.
Right. The suggestion is that CPR 19.5 may cover the present case, as I understand it, even if Section 35 does not. In other words, they're of different widths.
Covers in what sense?
The amendment.
And could you just tell us whose suggestion? Is this your suggestion or
no, as I understand it, it's the respondent's suggestion. If the respondent doesn't suggest that, then I need go no further.
But surely it's perfectly clear from Section 35, subsection 4 of the Limitation Act that you can't lawfully make a rule of court wider than what is permitted by 35.5. It says so virtually in terms.
Indeed it does. What it's saying is that you can't provide by rules of court for amendments which would be prohibited by 35.2 to be permissible in terms that are wider than those provided by 35.5 and 35.6. In other words, if you're caught by Section 35, rules can't make a wider gateway for you to go through than 35.5 and 35.6. And there are indeed cases which say, in effect, that is exactly right. The question, however, is whether 19.5 may catch you because it prohibits amendments after the limitation period, see 19.52, only in certain circumstances that are wider than those contained in section 35.2, because the wording is not the same.
I'm probably alone in finding this a little bit difficult, but at least for me, could you just take us through 35, 2, 3, and 5, and then CPR 19.5 with your submission as to how they apply to this case?
My Lord, my submission as to how they apply to this case is, I hope, primarily somewhat more straightforward. It is that section 35.2 is not engaged.
And that is because...
It's a procedural amendment only.
Well, A first. It's not the additional substitution of a new cause of action. Did you say that?
It's not the additional substitution of a new cause of action.
And that is because of Latang and Cooper and so on.
Latang, Cooper and so on, and the proper construction of the cause of action. What is the cause of action? Who has it?
And it's not the additional substitution of a new party because you say the party is...
It's not well, of course, it's an addition of a new party, but it's not an addition of a new party within the meaning of 35.2 because it's a procedural addition only.
Sorry, could you say it again?
It's not an addition of a new party within 35.2 because it is a procedural addition only.
Would it be, I'm just asking, would it be too simplistic to say that the kind of party they have in mind is a party against whom some claim is being directed?
An opposite party as opposed to a side-by-side party, which
Yes.
it's a concept known to the rules.
Or it could be a new claimant, could it not?
Okay. Yes, it could be. Sorry.
So then you go on to say, therefore, 35.3 has no application.
Therefore, 35.3 has no application, and that's it, if that's right.
Cause of action, that's because it's the same cause of action.
Yes.
It isn't a new cause of action because it's the same cause of action.
Well, that's right.
And going back to B, new party could involve not only a new defendant, but a new claimant. I mean,
Yes, of course it could.
In the procedural situation we envisage, the addition is of a new defendant, I think I'm right.
Yes.
But it could be regarded, it could cover a new claimant too.
My Lord, indeed. If it did not, of course, it would be a way around the Limitation Acts simply by joining somebody as opposed to letting that person bring their own new claim. That's why a new party can be a plaintiff or a defendant. He's a new litigant who enters the fray.
So subsection 3 you say doesn't apply.
If I'm right on my construction of 35.2,
But then go on if you're wrong.
if I'm wrong as regards that, I say that 5 and 6 are satisfied because the claim made in the original action, and that's the claim for damages, which is a claim for reflexive loss in respect of the negligence of the solicitors to the administrator, vis-à-vis the administrator, cannot be maintained unless the new party is joined or substituted as plaintiff or defendant in the action.
But before that, you have to have subsection 5 complied with. You say it arises out of the same facts.
Well, as far as I say it's not a new cause of action. If this was a new cause of action alone, I'd be home and dry is perhaps too tendentious way of putting it. But if this was simply assertion, oddly enough, simply assertion of a new cause of action, I would...
This is a new cause of action within subsection 2 paragraph A, contrary to your previous submissions.
Yes. Well, if that was what, if this application concerned, I think the Court of Appeal and indeed, as he now is Mr. Justice Morgan, accepted,
And me.
and I'm grateful Mr. Dumont, accepted that this claim would arise out of the same or similar facts as those pleaded. That would not be a problem at all.
Oh, yeah, could I have that again, just sorry.
I'm sorry. If one was simply considering the question of a new cause of action, it has been accepted throughout that the derivative claim that the claimant seeks to amend to arises out of the same, or within the wording of the statute, similar facts as those already pleaded.
So the condition in 5A, you say, would be satisfied on that assumption?
That would be satisfying, that's right. There's no problem with that.
And 5B?
5B, well, that's where we come back to the question of determination of the original action. And we say that the original action is the claimant here enforcing the cause of action, which is vested in the administrator, whether he seeks to bring a personal action or whether he's bringing a derivative action. So it is necessary for the determination of the original action.
And then you have to comply with 6A and 6B. A doesn't apply.
arise, so we're to look at B.
Well, on the basis that the procedural addition required by the Court of Appeal is viewed as one that falls in the Limitation Act, the Court of Appeal is saying that you cannot maintain the original action, as we define it, unless the new party is joined.
Well, the Court of Appeal hasn't said that about the original action, has it?
No, but we're
On
saying...
the contrary, it said the opposite.
They are indeed, that is what they're saying.
I mean, that's the very point you're challenging.
Indeed. That's why my argument relates to the construction of section 35, subsection 2, before we get to 5 and 6. But the original action...
I thought we were proceeding on the footing you've lost the point under subsection 2.
Well, indeed, this is an alternative submission, my lord.
But then you say you come within 6B.
Lord, we would do, that's our submission, yes.
I know it. Why do you come within B?
Because the original action, the action is one in which a person is enforcing a cause of action by a claim. The claim that he is asserting relates to the cause of action in the manner that I've indicated, and that is only one that can be properly constituted if you call it a derivative action and join the administrator on that footing.
But that's on the footing of no duty of care owed directly to the claimant, isn't it?
Well, my lord,
Because if there is a duty of care owed directly to the claimant, and you're entitled to rely upon the exception to Giles and Rind, then there's nothing derivative about it, is there?
my lord, that's right.
In which case you're stuck, because you can't satisfy 5B.
Well, my lord, if that were the only reason why we couldn't join a party, I'd quite happily accept that the original claim was a bad claim. It's something of a Morton's fork to be told, well, if you have a good claim, you can't amend. If you have a rubbish claim that you're not prepared to accept as a bad claim, we won't allow you to amend. You can only amend if you accept that your claim is bad. My lord, if that's what it takes, I'll accept the claim is bad.
Yes, I mean, if the analysis I've just put is correct, then you'd abandon that. You'd abandon your claim, would you, as originally pleaded? You'd say, well, this is a claim which can only proceed as a matter of law on a derivative basis.
Lord,
But that involves abandoning your whole basis of your original claim. But maybe, why not?
Well, it
Some
happened.
defendants like claims against them to be abandoned.
Yes, indeed.
Others like to have them for forensic reasons.
Lord, it often happens in applications to amend, as it did in Parkinson and Swan, that one is amending to join a new party simply in order to overcome that particular difficulty.
The point of 6B is to cure a procedural defect in the original claim, isn't it?
Yes, it is. Yeah. And there's no doubt, if one reads 6B in the context of the report, that it was there to deal with problems that arose where the original claim was defective, or whether where the position was that due to a change in a party being joined, you need to join a new party because of successive interests, that should be made permissible. So, yes, A is mistake and B is succession in essence.
But on this part of the case, if the only reason that the administrators have to be joined is because of the derivative nature of your action, and that wasn't a claim made in the original action.
Well, all that is true. If it has the consequences that your lordships indicate, then I'd be in grave difficulties in saying the original action could not be maintained without the joinder of the... Yes, I accept that.
So, again, for my benefit, probably alone, how do you put 6B?
The way I've put 6B, and I suspect it's not improving at all by, I'm afraid, it's repetition without skill, is that the original action relates to a claim in respect of a cause of action. The cause of action here was a cause of action vested in the administrator. Even if it is put as a personal claim, it is a claim in respect of the same cause of action, and therefore it's within the original action. Or if that's not attractive, it's not attractive. That's the way I put it.
Yes. Now, are you coming back to the rules? Because if we are we looking, going back to subsection 4, to see whether there are any further restrictions which the rules may impose?
My Lord, could I just have 1 moment?
Yes.
Lord, I'm sorry, your lordship was going to... well, your lordship made a point.
Well, I was wondering whether you were taking us back to the rules, or if we finished with the CPR.
Yep, my Lord, I dealt with CPR 19.5 in essence on this basis. If Learned Friend's case is that it's either the statute or nothing,
Yes.
then I don't need to look further at the rules. If, on the other hand, he asserts, well, if you're not within the statute, you're nonetheless caught by 19.5, which prohibits amendment outside the limitation period in certain points, then I have my further submission on 19.5. But to an extent, I'm in his hands as to whether I want to develop that or not.
And you prefer to wait to see how he does it?
Would you mind?
On reply.
If your lordships wouldn't mind,
Yes, I
I
think
can
that
respond
might
on
be
that if
sensible.
appropriate. It may be unnecessary. I'm grateful. Well, I'm also conscious that I'm past 3 o'clock, so I'm past the time that I indicated I was going to take in submissions. I can only say I bear that in mind, and I'll be a little bit quicker, I hope,
Yes.
In the conclusion.
Where are we in your written case now? Are we up to chapter 4? It's really beyond.
My Lord, I think 322 I just need to touch on. That's Robinson and Unicos, which is case 52 in volume 4. A decision of the Court of Appeal.
This is relating to which point?
Well, I'm afraid this relates also to the cause of action point that we spent a lot of time on, I appreciate. Can I indicate in brief, what I say Robinson Unicos illustrates. Robinson and Unicos was a claim brought in effect by partners in respect of a contract that was entered into between one partner and other contracting parties. It was an estate agent's contract. And the original pleaded assertion was that the third plaintiff, I think, had entered into that contract on behalf of all three plaintiffs. After the expiry of the limitation period, the plaintiffs wished to amend their claim to argue not that the third plaintiff had entered into the contract on behalf of all three plaintiffs, but that he had entered into it on behalf of the estate agency as it was then constituted, and that the estate agency had gone through various different changes of partnership, and that the entitlement to the benefit of the contract had been passed down through the various partners. And the judge at first instance said, no, that's a different cause of action because you're relying on different facts to assert your right. And the Court of Appeal said, no, it's not. It's enforcing the same cause of action. The cause of action is here the contract between the third plaintiff and the defendants. What you're asserting and changing by your amendment is a different way of relying upon it, or of obtaining the benefit of it. And that comes out most fully in the judgment of Mr. Justice Holroyd Pierce at pages 525 and 526. And can I take your lordship simply to the short sentence at page 526, about 8 lines from the top. His lordship says this: thus they are claiming the same relief, but they are amending their title, namely the intervening facts which entitle them to the benefit of the contract. In no sense is the nature of the action altered. The plaintiffs still wish to claim that which they claimed in the beginning, nor are they suing in a different capacity. Lord Justice Harman agreed. In my view, the first two plaintiffs were not necessary parties to the action, but they were joined, and the reason for their presence was wrongly assigned in the statement of claim. It's now desired to give the right reason why they wished to be parties to the action, namely that they were equitable assignees, as they say, of the benefit of the contract. The contract is the same contract, and I do not think that any new cause of action is raised by this amendment. On that simple ground, I would dismiss the appeal. Lord Justice Davis also agreed. My Lords, I've referred already to Parkinson Engineering Service in Swan. I won't repeat that. And your Lordships have already seen the policy of Good and Martin. That indeed is set out in Parkinson Engineering Services and Swan. And I've read that already. My Lord, paragraph 3.25 of the case is essentially a peroration as to the similarity of the claims. And my Lord, I've already, I think, dealt with that.
Yes.
And I don't think I need to repeat that. I'm grateful. Lord, there are alternative ways of putting the case. 3.27, timing of application to join new party. Your Lordships will recall that Her Ladyship, Lady Justice Arden, said that the claimant had to raise his amendment, in essence, all in one go. He had to amend his pleading, and he had to join the administrator all at one go. And it was that caused him the problem. It was submitted to Her Ladyship that it would be appropriate to deal with it sequentially rather than together. And if it was dealt with sequentially, there would be no problem at all, because it would be certain that the amendment, that the joinder would then fall within section 35, subsection 6b. Her Ladyship said that wasn't appropriate, relying on her own, I think, judgment in Giles and Rhines number 2, because she said the claim as amended would still fail to disclose a viable cause of action. If I can turn to that again shortly, that's authority number 21 in volume 2.
Can I just understand, your point, your position was, if only the court would allow you to amend, then then there would be a claim in respect of which you would then come in under 6B, is that
Yes,
right?
the oddity here is that if there's no problem if we assert a new cause of action, because we can get through under section 35(5)(a), which says you can rely on similar facts. That's not a problem. There's no problem if you've amended to assert your new cause of action, because you can get through on section 35(6)(b). You need to join this new party on the Court of Appeal's view in order to maintain your claim. So if you do that in 2 steps rather than in 1, you can do it. Why is it that if you have to do it in 2 steps, so that you can't do it? Her ladyship suggested the reason for that was due to her dictum in Giles and Rhine at paragraph 2. Her ladyship said this. It's authority 21 in volume 2.
Paragraph 2, was it?
Paragraph 2 of her ladyship's judgment. The application before the judge was an application for permission to amend. The relevant principles about the amendment of pleadings are not in doubt. The party should have permission to amend his pleadings so that all the issues between the parties can be effectively adjudicated upon, provided that any prejudice to the other party caused by the amendment can be compensated in costs, and provided that the public interest in the efficient administration of justice is not significantly harmed. Relying on Colborne and Greenwich LBC. Permission to amend should be refused if the claim, as amended, would fail to disclose a viable cause of action, either because it is statute barred or because the ingredients required for the relevant cause of action are not made out. On this appeal, Mrs. Rhine contends that the amendments should have been refused on the ground that they were statute barred. She also contends that the amendments would be unfairly prejudicial to her. My Lords, the facts of this case don't matter. It's simply that statement of principle. My Lords, if the Court of Appeal had simply permitted the amendment as sought, we would not have been statute barred. It is as simple as that. That claim could have been run. It may have been that subsequently...
Why?
Well,
Why wouldn't it have been statute barred?
Well, if we bring the claim, if your Lordships postulate that we amend the statement of claim to raise this claim, put to one side the question of joining anyone, there would be no question that this claim would be statute barred. We would be entitled to do that because we would go through the gateway in section 35(5)(a), because the facts arise out of the same facts as already pleaded. It wouldn't be statute barred. We also wouldn't be statute barred because it would relate back by virtue of section 35 subsection 1 of the Limitation Act. Lady Justice Arden took the view that it was necessary upon us to comply with all of what were perceived to be the procedural requirements at once. And that, in my submission, is a different thing.
Well, she probably took the view that otherwise you'd be driving a sort of coach and horses through the section.
Well, if
you could always do that, you'd remove almost the whole of the meaning of section or intent behind subsection 5 little b, wouldn't you?
My Lord, no.
By relying upon subsection 1, you say, oh, well. So in every case, you make your application to amend first. And that, under subsection 1, that has the effect of backdating it to put it in time, when otherwise it might be years out of time. So you say, well, there we are.
Well, what's paragraph 2 of Giles and Ryan got to do with this? It's a perfectly general statement.
Yes, I mean, I'm not sure which sentence you're picking up here at all.
My Lord, I'm afraid that's the provision that Lady Justice Arden
Which she
relied
refer-
upon.
She refers to this in her judgment in
Yes,
the present
paragraph
case.
36 of the
Yeah.
About halfway down, the court should not take the course proposed by Mr Adams. And that's the following.
It's just above letter H. Is it contrary to principle for the court to grant permission to amend merely to reflect a change of capacity?
Yes.
Because that in itself wouldn't enable the claimant to proceed to judgment.
Balance of paragraph 36.
And then the last sentence.
The
The other
same
way
must
around.
not apply if the amendment will not enable the party seeking to amend
Yeah.
to succeed on the claim he makes because the relevant parties have not been joined. My Lords, that is a priori reasoning, or bootstraps argument, whatever one likes to call it. Quite understand her ladyship in effect saying there is a good policy reason for doing it all at once, and therefore I'm going to treat it all as being done all at once. That too is a matter of procedure. I simply say that the authority cited for the proposition doesn't support it. There's really no good reason in these circumstances for her ladyship not to accede to Mr Adams' suggestion in that case.
But how does this defeat subsection 6b if you're otherwise wrong about it?
Well, remember, the application was to amend.
Yeah.
Consider the application to amend without the question of adding. An application to amend, to raise, if it's a new cause of action, if that's the conclusion of honesty, has to get through section 35(5)(a). It's accepted that that amendment would get through that hurdle. Once you're over that hurdle, the cause of action is there. It wasn't before. If subsequently, you apply to join somebody procedurally because they're a necessary party, if that's the view the court takes, you then get through 35 subsection 6 paragraph B.
But surely that's a procedural. I mean, if it is all part of the same litigation, that's a procedural device to avoid the true construction of, or the application of subsection 6 little b. It's picking and choosing out of the provisions of section 35, because if it's necessary or regarded as necessary to join in, if the effect of the amendment will, save in exceptional circumstances, require the addition of a new party, then you're, by taking it in these two stages and saying, well, when we get to the second stage, we don't have to worry about the first stage because we've already won, we've already got permission to amend. It makes a mockery of the whole thing, doesn't it?
My submission, no, indeed your lordship's really defines the point. If the joinder of the legal owners, say in exceptional circumstances, is required, the logical and appropriate way is amend your claim to raise your cause of action. Once the claim is amended and the issue is there between the parties can then decide by going to the court whether it is necessary to join the legal owner. It's not something you have to do at the same time. Indeed, logic would dictate you would do it subsequently. If the court should conclude that there are exceptional circumstances, presumably it can only do that once the issue has been joined by the amendment. Otherwise, there's nothing for it to consider. It's rather like the position in Prudential and Newman, where the court has to consider whether the claim is brought has merits or not. The claim has to be brought first. And then the court adjudicates on it, either procedurally or by way of preliminary issue. with respect, I'm not seeking to pick and choose. I'm certainly seeking to construe the matter advantageously. I'm not picking and choosing in a pejorative or illogical manner.
Well, we're about 10 minutes away from 3:30, and I think Mr. Dumont would want to get to his feet before the day is out. So,
Indeed, my Lord.
can we just complete your argument?
I'm grateful. My Lords, lastly this on section 35.
Yes.
My Lords, as you Lordships have heard, it's my submission that the court has a discretion as to whether to require joinder or not. It's a procedural matter. If the truth of the matter is that the respondents wish to have a party join, in other words, if their case to the court is, we insist you join this party because we need the protection of having him join so no one can sue us, or we want him joined so that we can seek costs, then the court should say, let him be joined. It shouldn't then go on to say, well, we'll treat him as being joined so that you can raise a limitation defence. That, in my submission, is having it both ways. It is having it unfairly. The position is either, and the true position here in these derivative actions, is either that if the party being joined doesn't care whether he's joined or not, there's no suggestion he does, the defendants can say whether they want him joined. If they don't, he won't be, and there's no question of limitation arising. If they do, it's not for them to stand and raise a Limitation Act defence. Because what they're really doing is seeking to say we want the benefit of his joinder, not so that we can get him joined, but so that we can have the amendment dismissed and the claim never brought. Lords, the balance of the submission deals with the Heim and Citibank arguments and the special circumstances point, in essence, which is the subject of the respondent's notice. And in view of the fact I've taken up so much time, I wonder if I might reserve my comments on that to any reply I may be able to make.
Thank you very much indeed. Thank you. Mr. Adams, do you wish to add anything? Thank you. Yes, Mr. Hunt.
My Lords, thank you for giving me the opportunity to start today. Can I start with the Limitation Act 1980? Because in our submission, the appropriate application of that Act is very, very different from what you've heard from Mr. Lowe. So if I start with section 35(1), we agree on that. A new claim made in the course of an action should be deemed to backdate the issue of the writ, 35(1)(b), other than third-party claims which we needn't worry about. 2, in this section, a new claim means any claim by way of a set-off or counter-claim, not this case, and any claim involving either addition or substitution of a new cause of action. That's not this case. We're not working on that limb. Or addition or substitution, addition it is, of a new party.
Sorry, you say A doesn't apply because?
Because my submission is that the primacy of B arises because a new party is involved.
What do you mean by primacy of B? Do you mean that
Well,
A could apply, but
A could, it may be that A applies and is satisfied, but that doesn't mean you get it through because you would also then have to apply B as well.
Could I just, for my own benefit, just have precisely what you say about A? Is it, you say, do you accept what's said by Mr. Blown, that the facts are the same and therefore the facts relied on are the same and therefore the cause of action is the same?
No, I don't say it's the same cause of action at all. But I do accept that that cause of action would arise out of substantially the same facts.
Well, that's going on, but
Yes.
that's going on to whatever it is, 5A. But
Yes.
what do you say about 2A?
I say that there is a new cause of action
Because,
because it is bringing a derivative claim on behalf of an estate
and
arising out of a breach of duty owed directly to the estate
how
for
do
a
you...
large. I'm sorry, I just
Yeah.
better finish though. For the estate's global loss, and one that's brought in a different capacity as well.
Well, just two questions on that. How do you fit that with what Lord Justice Diplock said in the Tang and Cooper? Do you say that there's no need, that there is a need to plead the facts relating to the derivative aspect of the claim?
Yeah. Lord Justice Diplock was, in Tang Cooper, was what he was saying was specific to that case as much as anything. He wasn't laying down a global rule. There was dicta by Lord Justice Millett and Paragon and Thakrar a couple of paragraphs down, which said, he said, what Lord Diplock was not saying. Lord Diplock was an appropriate shorthand for the fact that the case he was dealing with. But in our case, we have got a number of extra specific matters which need to be pleaded and which are different in the derivative cause of action than in the direct cause of action currently being maintained.
So are you adopting what Lord Walker said in Smith and Henniker? You remember that's where,
Yes.
I think I'm quoting correctly, that part of the cause of action is the title to bring it.
Yes. Part of the cause of action is
If that's relevant,
is the
it may not be
capacity to bring
relevant.
it or the entitlement to bring it. Yes.
Yes, in some cases it won't really arise for consideration, but if it does...
But it does here. Typically, here, it's one of the specific changes that they're trying to bring in by amendment. That they sue in a different capacity as well.
My second question was,
Yes.
you talked about global loss, but on my reading of the amended particulars of claim, Mr. Roberts is still claiming his 1/3 share.
Well, if he is, then it's still a defect in his claim. What he's probably done, what we all do in these circumstances, is you try and add as little in as you can get away with to get the amendment passed, but not to do less damage to what you've got on the paper. But what he says is, by reason, it's paragraph 10, I think, by reason of the negligence, this is page 49 in the core bundle, divider 5, by reason of the negligence of want of care of the first and second defendants, the claimant and the estate of Alice Margot Roberts, deceased, has suffered loss and damage. So that, as I understand it, is where he adds in the global claim for loss.
Unfortunately, my core bundle's fallen apart, but I think towards the end, where he actually says what he's claiming, it is his 1/3 share.
Does he actually say that? I'm not sure.
Oh, I see.
To which the claimant is entitled to one then
Oh, I see, yes.
in that
Yes.
farm.
Right, I would withdraw that point. Yes.
So he seems to be trying to include the extra global portion of loss there. So
That's A then.
let's say, so we're concentrating on 35(2)(b).
But just to be quite clear, so as far as A is concerned, you're inviting us to look beyond what Lord Justice Diplock said because of the particular subject matter of the debate in this case.
Yes. Because we're dealing with a more complex set of circumstances, which requires a more complex array of matters to be pleaded.
And what would those matters be?
I hope I gave them to you already, but it's
Yes.
the new capacity in which he sues, a representative capacity rather than a personal capacity.
Well, I noted you as saying that it's a derivative arising out of a breach of duty. Well, that's the same breach of duty as before.
No, it's not, because he only pleads a duty directly to him in the original plea.
No, wait a moment. Owed to is something that is the difference, as I understand it. Owed to the estate for the estate's global loss. So the duty, subject to the question of to whom it's owed, is the same. The factual background is the same, but you're saying the shift comes when you consider to whom it's owed and for what loss the recovery is sought.
Yes.
If, contrary to your argument, it were held that there were a duty of care owed to the claimant
And contrary
at a trial,
and contrary to Royal, Brunet and Tan,
well, maybe contrary,
which
would the claim be one of, would it fall within Giles and Rind on your analysis? The nature of the claim?
I'm afraid you're
Or
saying...
Johnson and Gore would, perhaps?
Well,
Or in essence, that's to say, is it the defendant's case that if he did succeed on liability, he wouldn't be able to entitled to recover anything because it would all be the trustee's loss?
no, the defendant's case so far is essentially that there is no duty owed.
I understand that. I'm asking what your case is in relation to the claim for damages on the hypothesis you're wrong about that.
Well then,
Because I understand you're not asking us or anybody else so far to strike the action out on the grounds of duty, so we must assume the duty, for present purposes at least.
yes,
And I'm just asking you what the defendant's case is,
the defendant
further down the line.
would then say if the personal action
Personal action, yeah.
carried through, the defendant would say that not only was there no duty, but that there was no, the appropriate person to sue for the loss was the estate. Yes, exactly.
And moreover, that he therefore can't recover anything in respect of any personal loss.
Yes.
Because it's...
Yes.
It all comes down to new capacity, because if you take a strict approach to Lord Justice Diplock in Latang, all that needs to be pleaded is are the facts relating to the failure to ensure that the other Roberts didn't pay the tax and simply claim damages. There will be no need to identify the precise, to distinguish between the loss of the 1/3 and the loss to the whole estate. So doesn't it all come down to the capacity point?
Well, in the pleading, isn't the pleading also, he says there's in his current pleading, before the amendment, a duty is owed to me as beneficiary.
But that's again in the traditional approach. You don't need to say that.
Well, with respect, you do, although in the context of a car action, one car crashes into another car. That's all that happens.
Yes.
But here, one's got a more complex situation, and there is a duty
Yes.
pleaded, which is a direct duty to an individual. If he's going to amend his claim, he's going to introduce a duty pleaded differently, a duty of care owed to the estate.
So if you look at paragraph 8 on page 49, you say he can't escape from adding in the words that he's added there.
Yes.
Because without them,
Yes.
we're back to where we were before, and there's nothing to indicate that the court is being asked to
Yes.
To make an award which reflects what you would submit as a correct position, that the duty is owed to the estate and the loss sustained by the estate.
Oh, yes, and in paragraph 9, there's an allegation. There's an allegation in paragraph 9 that he was instructed by John Langdon Roberts to act on his behalf on the sale of the farm. He's added in now allegation and to assist in the administration of the estate of Alice Margot Roberts, deceased. So that's another extra element. He's not just selling off a property on the simple instruction of an individual who has the right of sale, right of ownership, legal title, whatever it is. There's an extra factor has been brought in. which again shows it's a different cause of action.
So, let's see if I followed this, is that even on the very simple approach that Lord Diplock was arguing, this is a necessary fact
Yes.
which has to come
Yep.
in order to understand the scope of the duty. It's
Yes,
not
because
just
that's-
about the sale of a property.
Because that's
it's
the
actually-
retainer that's been, he's pleaded a specific and a different retainer under the
Yes.
current particulars.
But in paragraph 5, something very similar had been pleaded from the start.
Surely we shouldn't be going in for a detailed textual analysis of these pleadings. It's perfectly obvious that they're a bit of a shambles. And we need to sit back and see what the claim really is about and just how they do really relate. We ought to be looking at the substance of the thing. Speaking entirely for myself, it seems to me that's what we should be doing.
Yeah,
And not fishing about in the nitty-gritty.
Well, Lord, you're absolutely
These
right.
Extremely unsatisfactory pleading.
And also the whole concept of cause of action is, in my estimation, a bit of a red herring in any event. I know we've had an awful lot of time on causes of action today, but what I would accept...
Well, you can see it's within subsection 5A or 6A.
If it was 5A, we wouldn't be here. It's
I mean, the
because
cause of action
a new-
point is not really critical, is it?
No.
It's the 5B point.
5B, exactly, that a new party is to be added, and so one has to satisfy that. And what we submit is that 35.2 says a new claim means a claim by way of set of a counterclaim, means any claim involving the additional substitution of a new party. So the mere additional substitution of a new party is for this purpose a new claim, because that's what section 35.2 says. I'll have to deal with Lord Justice Millett's authority on that, but that's what section 35.2 says. In that there are two different types of new claim. One is a new claim involving a new cause of action. One is a claim involving a new cause of action, and one is a claim involving a new party. So
The addition of a new...
the addition of a new party, you're absolutely right. And our simple submission on that is that this is undoubtedly a claim involving the addition of a new party.
Well, they haven't applied to add a new party, have they?
Well, they're
leaving you to do that.
we were offered this in the Court of Appeal, and I accepted on behalf of my clients. I said we wanted them joined, and Lady Justice Arden recorded that in her judgment.
Well, on your application to join the new party, then the court will decide whether to join it or not, the new party.
Well, it's not...
But it's not their application, it's your application. It seems to me that there's some force in this point. You may say that there's nothing in it at all, but actually, this is a lot of dancing on the head of a pin. The truth is that we all know what the case is about. We all know what the case is about all along. And, of course, your clients want to avoid the whole thing on the grounds of the Limitation Act. I quite understand that. But the fact is that it's far from clear to me that your clients really need the addition of this new party in order to protect themselves.
Well,
If they did, it may be that some arrangement would be made with the trustee and so on. But
Well, can I just explain one of the concerns about our clients, particularly on this issue, is that if this new derivative action is allowed, the liability quantum goes up very, very significantly, hugely. It's hundreds of thousands of pounds potentially, rather than tens of thousands of pounds. And that is a recovery for the benefit of Her Majesty's Revenue and Customs and another beneficiary, one other beneficiary at least, who will not be having to put their hands in their pockets or take the risk of that litigation being successful at all, but will obtain the fruits of it by some application of which they are in complete ignorance, leaving us to face a publicly funded litigant who has only joined in all these people who he hasn't contacted to
But I'm
bolster the
quite full
claim.
of the hasn't contacted point, and that if we were exercising a discretion of some kind, all those might be really very, very relevant consideration. But we're on a much narrower question of how the time bar operates.
Well, fine. Then let's go to that. This is a claim, we say, involving the addition of a new party.
Please go.
I'm sorry.
So I really am very, very confused about this, because I do think that this court is entitled to know whether we're hearing this appeal on the basis that the application to amend is what we've got at page 46 and following of the appendix, or is something else. And the more counsel go on, the less clear I am about what this appeal is about. Because the amendment at the moment does not provide for Mr. Sainter to be joined as a party.
No.
All it does is, and I'm looking, as I know the friend is doing, is looking at page 46, which is changing from on his own behalf to representing the estate. And
What Lady Justice Arden decided in the Court of Appeal, and the unanimous view of the Court of Appeal,
they thought that was adding a new party. Did
was that if this was to be done, if this application to amend was to be made to bring a derivative action, then the personal representative should be joined as a defendant to the action. It was, when Millennium opened the case this morning, almost the first sentence he said to me was, I accept that it was appropriate to decide that the administrator should be joined.
appropriate? It was a necessary step.
Yes. You have the same note.
He said that procedurally it was appropriate, and throughout his submissions it became apparent that he was using procedurally in a very special sense and a limited sense. But I mean, the fact is that there's an agreed statement of facts and issues. An issue to must a beneficiary claimant seeking to bring a derivative action join the trustee or personal representative of the party. Are you telling us now that isn't an issue in the appeal?
No, we say that he must.
But you
Join-
well,
I'm sorry.
Right.
We say he must join the personal representative. And they say they don't have to join the personal representative. So therefore it's an issue in the appeal, isn't it? Yes, we hope to phrase that issue in a way that reflected the differences between us. Must a beneficiary claim seeking to bring a derivative action join the trustee or personal representative as a party? And it's our case that he must. It was the Court of Appeal's decision that he must. And that's why Section 35(2) was engaged. Because, therefore, this is a claim involving the addition or substitution of a new party outside the limitation period. And that's what Section 35 was all about.
Suppose the defendant, suppose the new party said waived the right to rely upon the limitation period.
Suppose
the trustee.
No, it's not the trustee, it's our limitation defence.
Quite. I quite understand that's your argument.
The trustee can't waive a defence that's...
Not for you, but he could for him.
How can you take a limitation point on behalf of somebody else?
No, I'm taking a limitation point on my own behalf.
But
Because the estate is time barred in its claim against my clients.
But even leaving time bar aside, and maybe I've got this wrong, but I would have thought you would, once you see a derivative claim of this kind, you'd want to be sure that all the parties who had claims through the estate were party to the action.
Absolutely right.
And that's why the personal representative, you say, has to be there in order to protect you against subsequent claims on the same grounds by other people.
Yes,
Yes, but this case is not really about that.
Well,
I quite see that
No,
that's
that-
what the authorities show, but that's what this case is about. You want him joined so you can take the limitation point. That's what you want him joined.
We would
in
want-
real life.
we would want him joined in. If the limitation period was still alive, we would want him joined, arguably to obtain costs against him, although there appears to be nothing in this estate. There appears to be nothing in this estate, one doesn't know. Also, to wrap up any other potential claims, because if only John Roberts is us, how do we know that the revenue can't then run that claim? So, if the limitation period of the estate was still alive, we would want him involved anyway. And in fact, as it happens, the revenue might not be bound by the same limitation principle. So it might be that there was still something left loose there. But primarily, we're fighting on the basis of a limitation claim because the current claim of the claimant is hopeless. And it's only if he can recast it as a successful derivative claim that he gets even to a threshold of having any claim at all that he can run.
Apart from the revenue, who else could bring, assuming that they could somehow or other do, who else could bring a claim at this stage?
At this stage, only the revenue could bring a claim because anybody else is time barred.
Anyone else's time?
Yes.
So, and the revenue are not time barred, is that right?
No.
How does I'm sorry, I just don't know how that works. Just asking.
But can I take you to the crucial Law Reform Committee report on which Section 35 was based?
Sorry, is there an answer?
I'm sorry, I'm terribly sorry.
So I'm just asking. How does it work that the revenue are not time barred? I'm just asking.
Well, the revenue has no time bar for its claim for tax against estates. And it's possible, therefore, that it might have some claim in relation to an estate asset that was still a live asset. Now, it's not clear to me that a tort or contract claim against this could still be a live asset.
It is an entirely different cause of action.
Yes. It would be wrapped up in any, if the estate were joined there. But it's not something I've given a huge amount of thought to, the revenues claim, but it's certainly true that if money is recovered, the revenue have got a claim to it. So the revenues interest in the estate are not time barred. Whether they can enforce anything against us may or may not be sure, but often one likes to tie up claims irrespective. But in our submission, the key to understanding Section 35 is to look at the Law Reform Committee's report. Which is in Volume 1 of the Authorities at tab 4. And the paragraph we started is on page 68 there, paragraph 5.16, amendment to add a party. It says the current discretion of the court to add a new party after the expiration of the limitation period is at present regulated by Order 20 Rule 5.3, and that is only if there's been a mistake where nobody has been taken by surprise. So that's the current position. 5.17, therefore, there are, however, not wholly dissimilar cases where the existing formulation may cause injustice. That is, where the plaintiff has made an error of law or procedure, the correction of which would not occasion anyone to be taken by surprise. If, for example, the equitable assignee of a debt sues the debtor without joining the assignor, and the limitation period then expires, he cannot amend his pleading so as to join the assignor. So that is an example of the problem that is the Law Reform Committee have analysed, have identified. And they give us authority for that, Hudson and Ferneyhough. Now, Hudson and Ferneyhough is authority for that proposition. And I'd just like to show you that it is, because it's been suggested that it isn't. And it appears in volume 3 of the authorities at divider 29. And this is a short report, but if I can just take you through the facts quickly. Appeal from the decision of the Divisional Court, Lord Coleridge and Miss Justice Matthew. The defendant, on October 20th, 1883, gave an IOU to a man named Stanley for £42 money lent. On September the 25th, 1889, so that's 6 years later, but still short of the limitation period, Stanley transferred the IOU for value to the plaintiff. And on September the 27th, a couple of days later, the plaintiff issued a writ against the defendant claiming the amount. No notice of the assignment was given to the defendant, so it was still an equitable assignment, not a legal assignment. But on October the 21st, the day after the period limited by the statute of limitations expired, the plaintiff took out a summons to amend the writ by adding Stanley as a party. The master made an order giving leave to amend on condition that the plaintiff should be in no better position with regard to the statute than if the writ had been issued on the date of the application to amend. So he says you can have the legal owner, but only from a date by which time the claim is your claim will be statute barred. So the plaintiff appealed that. Grantham Jail Chambers reversed this order and gave unconditional leave to amend. The Divisional Court restored the order of the master, holding the plaintiff ought not to be allowed to make such an amendment as to take away from the defendant a defence which had already accrued to him under the statute of limitations. The plaintiff further appealed. The court, Master Lord Isham and Lord Justice Fry, dismissed the appeal. Isham, the effect of allowing an unconditional amendment would be to seriously affect the defendant's position. If Stanley had been the plaintiff in the action, when the writ was issued, statute of limitations would have been barred. But the sole plaintiff at that time was the assignee of the IOU. The assignment was, by Section 25, not effectual without notice to the defendant. Before that act, there could be at common law no transfer for shows in action. All that the assignee would get would be an equitable right. That right, if he had it, was in no way affected by the order of the master, but it would not be right in such a case to allow an amendment on any other terms than that the defendant's position should not be prejudiced by it. So that case establishes that where a legal assignee wants to sue, where he brings a claim, doesn't join his assignor, seeks to join the assignor after limitations expired, he can't get permission to do that.
What do they mean by allowing an unconditional amendment, and would it be right to allow an amendment on any other terms than the defendant's position should not be prejudiced by it?
Well, an unconditional amendment, I suspect, would have been an amendment which dated back, because it was allowed...
Yes, no better position with regard to the statute, yes.
Exactly. So, this was the mischief that was identified by the Law Reform Committee. And that was at 517, halfway down that paragraph. And then the committee report goes on. Secondly, if the plaintiff is one of two or more persons of a joint right of action, a person entitled jointly with him, for example, a co-trustee, may be a necessary party of the action and cannot be joined after the limitation period has expired. We think it would be desirable that the rules of the Supreme Court should permit the addition of a new party in circumstances of this kind. And then over at page 5.20, we have identified the following cases in which we think a new party should be capable of being added by way of amendment post-limitation. 1, where the plaintiff is beneficially entitled in equity and the person with the legal title is a necessary party to the action. For example, the equitable assignee of a chosen action who cannot sue without joining the legal assignor and relies on performing rights society. The Setiki Trust, this is another one, and it's directly referable here, who cannot enforce a right of action against a stranger to the trust without joining the trustee. And then he gives other examples. 2 is where 2 or more persons jointly entitled to a right and all of them must be joined in order the right may be enforced. For example, an action to enforce a right vested in trustees. And that is similar to the example given by Lord Roger this morning. 3, where the plaintiff is suing to enforce a public right and the action is one which ought to have been initiated by related proceedings, namely the Attorney General. Plaintiff is shareholders suing to enforce a right vested in the company, and the company is a necessary party to the action, company derivative action. Or where the plaintiff is suing to recover from persons jointly, but not also severally, liable to him, and where his failure to join all of them would, as the law now stands, mean the liability could not be enforced at all. So those were the cases which it was intended to correct with section 35 to B, the second 35.2. And that is the case has been recognised by Lord Justice Millett in the Yorkshire and Fairclough case, which I'll take you to in a moment. But what that means, therefore, is that these cases which the Law Reform Committee was trying to cover were cases where there was already an action on foot in a particular capacity, but because of the want of joinder of a specific party, either the sole legal owner or a co-legal owner, that action couldn't be maintained outside a limitation period.
But the words are original action in 5B.
Yes.
So doesn't that mean that you have, on this point, you have to also say that it's a new cause of action under 35.2a?
No, because it's under 2B, the original action, all you're looking at is the original action. You're not looking at any, there's no other action that's being considered. (5B) says, in the case of a claim involving a new party, if the additional substitution of the new party is necessary for the determination of the original action. The original action means the action before the new party is added to it.
Yes.
In this case, if the amendment had been made, which was asked for, and nobody had raised this point, but then subsequently somebody thought, well, we better get them in, they applied, at that stage, the original action would be one which included the amendment.
Yes.
As amended. It had
Yes.
already been amended.